Assalamu alaikum and welcome to the free legal advice show on British Muslim TV. My name is Riffat Hussain and I am your host for the next hour. This show is designed to serve our viewers by answering your legal questions in relation to English law. There are two ways in which you can contact me this evening. Firstly, by calling into the studio and speaking to me live on air. Secondly, if you wish to remain anonymous or do not wish to speak live on air, then you may wish to send your message through WhatsApp. Both numbers you can see at the bottom of your screen, and I will be delighted to receive your questions and answer them for you this evening. Just with some guidance in respect of the questions, try and provide as much detail with regards to your query so that I can give you a tailored response. If your question is not clear, then I may only be able to give some generic advice around the topic that has arisen from your question, and it may not directly address the concerns and queries that you have. So please do take the time to provide as much detail as you're able to so that I may address the question for you. If you feel that I haven't addressed the question, then please feel free to send a follow-up question or ring through live into the studio and I will elaborate further for you. I do have a number of questions already, and I thank our brothers and sisters for sending these through in advance. I will turn to those now, but as I say, if there's anything that I have missed, or if I've misunderstood your question, then please do feel free to follow that through so that you are satisfied with the response that you have received. The first question I have is in relation to a sister who says, Salam, I have a question. I am divorced from my husband and live with my 3 children. He left and went abroad and remarried. I have taken khula from my Islamic marriage. How do I apply for maintenance when he is abroad? He is a British citizen who has dual nationality. All his money and property is abroad. It's a difficult situation that you find yourself in. In relation to child maintenance, there are a number of avenues that you can pursue. The most obvious one and the most common one is where the parents usually enter into an agreement that they are both satisfied with, and therefore there is no need for any other agencies or any further action. Clearly, sister, you're not in that position as your husband is overseas and presumably is not in contact or willing to enter an agreement around child maintenance. The Child Maintenance Management Service, or Child Maintenance Service even, is an organisation that would usually assist with such inquiries. Usually they would only get involved if both parents are habitually resident within the United Kingdom, and there are other criteria for them to assist you. The best course of action would be to call them, and if you do have a pen and paper handy or another mechanism of taking note of this telephone number, then I will provide you with the telephone number of the Child Maintenance Options Service. They will be able to take some further details from you and guide you further as to whether or not they can assist. Usually what they would ask for is your national insurance number, your name, address, details of your children, and also details of your partner or former husband. You may, prior to ringing this service, also contact the Citizens Advice Bureau, who'll be able to give you some more thorough advice about the criteria, because, as I say, the difficulty in your case is that your former husband is no longer resident in the United Kingdom, and from your question, neither is his property or his assets, and so there's no indication that he intends to return to the United Kingdom, and so whether or not the Child Maintenance Service is able to assist you in those circumstances would be something that you need to explore with them. There is usually an application fee to apply for child maintenance. This is around £20. There are certain exemptions, particularly if you have been a victim of domestic violence, for instance. And again, that's something the relevant agencies that you contact will be able to explore with you. Moving on to the telephone number for the child maintenance options, that is 0800 953 0191. I'll just repeat that again. That's 0800 953 0191. And that service is available Monday to Friday between 8 a.m. and 8 p.m. I hope that does answer your question, sister. Moving on to the next question, and again, thank you for sending this through. Assalamu alaikum, alaikum assalam wa rahmatullah. I need some advice regarding my mother. She came from India on a 2-year visa. I would like to apply for her permanent visa, but she cannot travel back to India due to COVID restrictions. What are my options? Unfortunately, again, the question does leave a few vital details out. You say a 2-year visa. It's not clear in which category. Is it a 2-year visit visa, for instance, or is it a visa in another category? Permanent residence on what basis? Is it because your mother is no longer able to care for herself and is requiring those care needs to be met by you? If you watched my program last week, I did address some of the issues and difficulties around the dependent adult visas when applying from overseas. So I'm sorry I'm not able to address the question fully, as I say, there are those vital details missing. However, with regards to your mother not being able to return to India due to the COVID situation, that there are provisions within our rules that help with that. The situation may have changed. Clearly, our travel advice has moved on recently, that there are no red lists, and India was removed from that list prior to these changes in any event. I'm not sure if what you're saying is that India is not accepting its citizens back from the United Kingdom. I'm not familiar with the circumstances there. However, if your mother is unable to return to India due to the COVID restrictions, then there is an application that can be made known as exceptional assurance. And exceptional assurance covers individuals who are currently in the United Kingdom, whose leave or visas are due to expire, but they are unable to leave because of the COVID situation, either because you're prevented, the country won't allow you back, or because there are quarantine restrictions, but they are so oversubscribed that you would not be able to access those. And therefore, in theory or in practice, you're unable to return because you're unable to comply with those. I can't comment specifically in respect of India. I don't know what the situation is there and whether or not there is a red list and whether or not you would be prevented. I assume from your question that that may be the case, but an exceptional assurance application will allow your mum to remain in the United Kingdom. Again, the permanent visa, it may be possible to make the application from within the United Kingdom whilst you're on the exceptional assurance. But again, it would depend on which particular application you're making and the particular circumstances surrounding your case. But that is something that I would advise you to look into. The exceptional assurance also allows a disregard for any period of overstaying between, I understand, January 2021 and August 2021 for these purposes. So where you've been prevented to leave and would have done otherwise in a timely manner, but could not do so because of the COVID restrictions. Again, the Home Office will disregard some periods of overstaying if it is satisfied that was the reason why you were unable to leave and that resulted in you overstaying in the United Kingdom. Again, thank you so much for that question, and I hope that does address your query. If I have missed anything or misunderstood your question, then please feel free to ring through into the studio, and I will go through that in more detail with you. Alternatively, follow that through with a question on WhatsApp, and I will pick that up for you. Moving on to another question. I have a question. I have been granted 10 years as a parent route. My extension is due soon. I just want to ask, which form do I need to fill? I am a single parent. Thank you. I understand that this may be a follow-up question from the same person. And also, I have been allowed to public fund. Do I need to request again for public funds? Again, I did touch upon this in one of my previous shows, and if you missed that, then the question is in relation to an immigration application. This individual, a single parent in the United Kingdom, has been granted status on the 10-year route to residence. The 10-year route to residence is usually granted where an individual parent will have British children from a relationship, or children who have been in the United Kingdom for a period of 7 years, having been born here, and therefore it is deemed unreasonable to remove those children. And by virtue of that, the parent is then permitted to also remain in the UK to allow for the children's welfare and best interest to be served. So the questioner asks that they are on this 10-year route, and which form they would need to complete in order to apply for their extension, and also they were previously allowed to have access to public funds. Usually in these circumstances, public funds are denied. There is no recourse to public funds. The question does require an in-depth answer. I will go to a short break before I come back and revisit that. Please keep your questions coming in, and I will see you on the other side of this break. Assalamu alaikum. Welcome back to the Free Legal Advice Show on British Muslim TV. I am Riffat Hussain, and I will continue to be your host up until 8 p.m. Thank you for joining us this evening, and I will continue to address any questions sent through by you in respect of English law. In order to participate in this show, you can ring through into the studio live and speak to me, and I will address your question. If you wish to remain anonymous and don't wish to speak to me live on air, then please feel free to send through your questions on WhatsApp, and I will address those as I go through this evening. Just as a word to guide you in respect of the questions you send through, please make sure your questions are detailed enough so that I may address them directly. If there's lack of detail, then it may be that I can just provide a generic question which may or may not answer your query directly. If you feel that you have sent through a question and I've either misunderstood or not addressed it fully, then feel free to call into the studio or send a follow-up question on WhatsApp, and I will address that for you. Before I proceed to the question sent through on WhatsApp, I do have a brother on the line. Inshallah, I will take this call. Assalamu alaikum.
Hello, assalamu alaikum.
Alaikum assalam.
Yeah, hello. My question is, I came from Italy.
Yes, brother.
I applied for my brother for EEA family permit, extended family member.
Yes.
So my brother appeal was allowed.
Mm-hmm.
After it's almost 3 months now, I haven't heard anything from the Home Office. However, Home Office in the meantime, Home Office sending letter to people stating that they're not going to issue the permit as the route is ended after 30 June 2021. So my question is Home Office going to issue the family permit or not?
Thank you, brother, for your question. Sorry. And did you say there was another question?
So my question is Home Office going to issue the family permit for extended family member or not? Or what should I do as my appeal was allowed?
And are you legally represented at the moment?
Sorry?
Are you legally represented? Do you have a solicitor at the moment?
No, I don't have any solicitor. I did it myself.
Right. But brother, if you continue to listen, I will address your question now, and thank you so much for calling through with that.
Okay, thank you very much.
Thank you. So the brother has a question in relation to an extended family permit under the European regulations. For those of you who are not familiar with this regime, when we were part of the European Union, we also had the European regulations which allowed European nationals to enter the UK and governed their free movement and the invitations and the sponsorship of their family members to join them in the United Kingdom. As with Brexit, those arrangements came to an end, and the deadline for family members to apply in this manner was the 30th of June 2021. This brother's question is that he had applied for his brother prior to this happening, and the application was refused, and then proceeded to an appeal before the Immigration Tribunal. The brother tells us that the appeal was allowed, so the judge accepted the application, and therefore he was in a situation where he was waiting for the family permit to be issued and his brother to arrive. He is aware that other people in a similar situation are now receiving letters from the Home Office advising that those family permits will not be issued because the deadline has now passed, and therefore they are no longer eligible. Brother, I am aware of this situation, and I believe that there is litigation at the moment to challenge that position. It is still a relatively early days. The Home Office has only recently started issuing these letters, and so there are no concluded cases in terms of the litigation that proceeds. You will be advised to seek some further legal advice from a local solicitor, because your option may simply be to judicially review and challenge the lawfulness and the legality of the Home Office refusing to implement a decision of the court. So that would be your option. Of course, you said that you haven't received that letter directly yourself, and you can't therefore challenge a decision that hasn't yet been made. So you would need to wait until you yourself receive a similar letter. It may be that you are issued with a family permit, but if you are not, and the Home Office then sends you a letter advising that they will not issue a permit, then that is the decision that you will be seeking to challenge. So you do need to have that before you take your next steps. With a judicial review, usually the time limit is as soon as practicable. But the absolute deadline would be certainly within 3 months. So as soon as possible, but no longer than 3 months. There are huge cost implications and other implications in respect of judicial review proceedings. Please do not enter such proceedings lightly. Do be rightly guided with sound legal advice prior to taking any such action. But that is the advice that I would give you. Wait to see what the Home Office do, and then seek legal advice in respect of your options. But the likelihood is that if you do receive one of these letters, then your option is to judicially review that and challenge the legality through a solicitor, well advised. In terms of the cost implications, what I mean by that is if you do bring judicial review proceedings and if you lose, then you not only bear your costs with regards to the judicial review, but you also bear the costs of the Home Office lawyers, government lawyers, who will be, charging a significant sum of money at that level. So please do not get yourself into that position without having proper legal advice and guidance in place. I hope that does address your question, brother, and I hope that the situation doesn't arise where you are in that position. But if you are, then do follow that guidance through. Thank you so much for calling in and posing your question. So I now move on to another question. This question has come through WhatsApp. It was the question I was addressing just before we went to break. It was in relation to an immigration matter where our brother is on a 10-year route to settlement. coming up to an extension and is wanting to know which form. The forms are not as relevant these days as they used to be in the past. We've moved away from the paper forms onto a digital platform, and usually you can find the right platform by searching which type of application you are seeking to make. So extension parent route, for example. Please always ensure that you are clicking onto the website that has the .gov.uk at the end. That should give you the satisfaction that you are, or the assurance even, that you are on an official government website and not somebody else's website who is therefore trying to sell their services through a platform. And if you do that, that should usually bring up the right form for you. With regards to the form, if you do want to search the form, it's FLRFP. That's the further leave to remain, family and private life. So FLRFP. If you search that, it will still take you to the online platform because there is no form to download, but that will take you to the right place, and it does ask you to checkbox the category in which you are applying. So just double check that you are applying in the right category. The category applies to you. Don't fall into the mistake of ticking child. It will assume you're the child, not that you're applying on the basis of a child. So do tick the parent option on that screen, and that should hopefully take you through the correct form. If you are unsure, then please ask somebody. Most solicitors offer a consultation. It's vitally important that you get these applications correct, because if you do not and your application is refused, you do risk losing the time that you've already done on that 10-year route. So you risk going back to the start of your 2.5 years or the start of the 5 years, whichever point you are at now. So please do seek legal advice and guidance, because the implications of not doing so can be quite dire sometimes. So I hope that answers your question. With regards to the question on public funds, usually if public funds have already been, permission to access public funds has already been granted, then that will continue. There is no separate application at this stage that you would need to make. If you do, however, get your application through and the condition of no recourse to public funds has been applied again, then simply that there is a form that you can fill in asking for that to be removed, setting out your particular circumstances as to why access to public funds should be permitted. If you're a single parent of children, and my experience is that would automatically be applied and you don't need to reapply for that. I hope that it really does address both of your questions. If I have missed anything, then please feel free to contact me again. Thank you for that. Moving on to another question. Assalamu alaikum. Alaikum assalam wa rahmatullah. I got married to my husband, who is an asylum seeker. We have been trying very hard for him to settle in the UK. He has been in the UK for 18 years. I am a housewife, so I don't have anything to rely on. His asylum application has been refused. We are now about to apply for an appeal. We have no children of our own. I am a British citizen and my husband is from Bangladesh. He has been in the UK since 2003 and the solicitor isn't really helping us. We are spending lots of money with no results. Could you please suggest anything? Inshallah, I can do. That there's a lot to unravel with your question, sister, but thank you for sending that through. Just to kind of summarize what I've understood of your question. So again, a question relating to United Kingdom immigration law. Your husband has been resident in the UK now since 2003, but is essentially a failed asylum seeker from Bangladesh. You mentioned that you are currently in the process of appealing. You haven't said in what category. Are you appealing because his asylum application has been refused, or have you made another type of application, for instance, based on your relationship, and that's been refused, and that's where the appeal lies? Please do clarify that for me, because that will assist me in guiding you. I am going to move on to a break, so I won't start answering your question now. What I would say is please keep watching, and I will see you on the other side of this break with your answer. Thank you very much. Assalamu alaikum and welcome back to the penultimate segment of the Free Legal Advice Show with Riffat Hussain on British Muslim TV. Just before we went to break, I was addressing a question from our sister with regards to a number of immigration issues that her and her husband are unfortunately facing in the UK. Before I move on to their question, please feel free to send through your question, either by calling me live in the studio and speaking to me directly, or alternatively by sending a question through on WhatsApp. Please make sure you provide sufficient detail for me to be able to address your question. If you don't, then I will raise that with you, but I will also try and provide a generic question in the hope that that addresses your query. If I do ever miss parts of your question or I have misunderstood your query, then please do feel free to follow that through so that I may help you in understanding your legal position. Just before we went to break, I was answering a question from our sister who is currently in a marriage to an asylum seeker from Bangladesh. Her husband is a failed asylum seeker and has been in the United Kingdom now since 2003. The application for asylum has been refused and an appeal has been lodged. And thank you, sister, for clarifying that over the break. There's a number of issues that the sister raises. Firstly, with regards to asylum, sister asks what the outcome of the asylum appeal will be. Without having seen the details of the case and the reasons for refusal, unfortunately, it would be very difficult for me to advise in respect of an outcome. The judge will look at the evidence presented before him or her on the day of the hearing, and will then come up with a reasoned decision as to whether the appeal is allowed or whether the appeal is dismissed. Looking at the question, so as I said, that there are a number of key issues, and I'll address those in sequence. The first one being the obvious one, the asylum application. I suspect one of the reasons why the application may have been refused for protection or asylum in the UK is due to the delay in making that application. And again, as lawyers, we see this regularly where individuals have come to the United Kingdom and then failed to notify the authorities of their presence and the reasons why they are unable to return to their country of origin. This may be because somebody has entered the United Kingdom with a valid visa and therefore feels that they are lawfully in the United Kingdom and they don't need to approach the authorities immediately. It may be that they are illegally entering the United Kingdom and fear return to their country of origin, but delay always leads the Home Office to concluding that an individual is lying, they lack credibility, and therefore they have evaded the authorities and have only made the claim for protection or asylum when they have been apprehended by those authorities. And therefore, it weakens the application. And often the Home Office cites this as a reason for refusing. And the majority of judges are persuaded by this, although they will look at the other circumstances around the case. A vast delay of this nature usually does have or does raise concerns with a judge as to why an individual has not presented themselves sooner. So, address that as part of the appeal. I note that you are legally represented. You mentioned that you are paying your solicitor. Please be advised that there is legal aid available for protection applications. So that's asylum applications applications based on human rights where an individual will suffer serious harm, inhumane or degrading treatment. Some of you may have heard this referred to as Article 3 type cases. It may involve cases where an individual has significant health problems. Those categories are still categories where legal aid is available, and therefore if your current solicitor does not hold a legal aid contract, you may seek to instruct a solicitor who is, and your current solicitor will be able to advise you of local solicitors and firms who are able to assist on those terms. There is sometimes a perception that if you engage a solicitor who holds a legal aid contract and is dealing with your case under legal aid, that they somehow provide a lesser service. That's a myth. It has to be a myth because solicitors holding legal aid contracts are held to higher scrutiny, both by the Solicitors Regulation Authority, but certainly by the legal aid agency, who then pays those funds for these individuals to be represented. And like any organisation who is investing their funds, they want to show that they are getting value for money and that individuals are not abusing that system. So again, if you are struggling with the fees, have a conversation with your solicitor, and it may be advisable that you are able to access a legal aid lawyer locally who is able to then take your appeal further for you. You mentioned that you are a British citizen. Again, that will be part of your appeal that the judge will consider in respect of your family life between you and your husband, and whether that should be a reason for him to stay in the United Kingdom. Again, you mentioned that you have no children, and so the judge has to balance a number of conflicting priorities and rights and responsibilities. So the judge will look at not only your private life and your family life between you and your husband, but the judge will also look at the economic welfare of this country. We can't allow people to enter the United Kingdom illegally and reside here, form relationships and then stay, because that's not within the economic welfare of the United Kingdom. Likewise, the judge will look at the greater public good. What would be the public's view of individuals being allowed to break the law, enter the United Kingdom, and then remain here on the basis that they have now formed a relationship. And the statutory guidelines that the judge is bound to consider clearly provide that any relationship that has been formed whilst an individual is in the United Kingdom unlawfully must be given little weight. If there are children involved, then that changes the dynamic, that the welfare of children must be considered. And particularly if those children are then British, their removal from the United Kingdom would breach their rights. So there would be a wider consideration. But as you have no children, that your relationship status, unfortunately, is likely to be a weak one. The argument being that it would be reasonable for you to return to Bangladesh. So, of course, you are entitled to a family life, but there is no guarantee that that family life should be within the United Kingdom. You return to the country where your husband has lawful residence. I know at the moment ignoring the fact that he has a protection claim and says he's in danger. But that failing, the judge will look to see, that there are no, if the judge finds that there are no protection issues and there is no danger to your husband, or that there is, but it's confined to one particular part of his country so he can move elsewhere, then the judge will realistically look at whether or not you can move to that country. And there will naturally be some hardship to you. You mentioned you are a British citizen. One can assume that you may have been in the United Kingdom for a long period of time, if not born and bred in this country. But it's a choice that you make as an adult. And the way the courts interpret that is you then bear the consequences of the choices you make. If your choice is to enter into a marriage with a person who's illegally in the United Kingdom, then you can expect to be either separated due to those circumstances or to follow your husband or partner to a country where they do possess lawful residence and can invite you lawfully to join them in that country. If you don't want to do that, then that is a matter for you, not a matter for law, unfortunately. So quite a broad question and issues there for you. The other thing I do note is that you mentioned that your husband has been in the United Kingdom since 2003, which means that he's coming up to 20 years residence in the United Kingdom. And so there is a route under the immigration rules. He's not there yet. He's admittedly a couple of years short. But depending on the position that you find yourself in, he may at some point in the near future be able to satisfy the immigration rules on the basis that he has been in the United Kingdom for 20 years. Huge evidential requirements around that, and on whether or not that would be met is something else that you can discuss with your solicitor, but you're not quite there. You are still short of him meeting that, but that is something else that you may want to consider in the coming kind of period if you do reach that point. There's another question here, and brother, I'm so sorry, I'm not sure that I fully understand the question. I will read it out, and forgive me if I've misunderstood, but I just want to know, what's the chance of 10-year immigrant policy about visa? I already did fingerprints 7 months ago, but they haven't replied to me. Can you please guide me? Brother, if you could just elaborate on your question for me, just so that I understand fully your position. Are you asking about the 10-year route to settlement as either a parent, partner, or under a similar category? Or are you asking a question in relation to the 10 years lawful residence, which then leads to settlement immediately? So the indefinite leave to remain, because you have been in the United Kingdom for 10 continuous years lawfully without any break in your residence. Upon receiving the clarification of your question, I will address that further for you. I will, however, provide some generic information on both of those routes, in the hope that if you don't come back to me, at least it may address some of your queries around this topic. We are proceeding to a short break. Please do continue to send your questions through, or even better, please call through and speak to me live on air. I will see you on the other end of this break. Please do come back and join me then. Thank you. Assalamu alaikum, and welcome back to the final segment of the Free Legal Advice Show on British Muslim TV. I am your host, Riffat Hussain, and thank you so much for joining me this evening. I was addressing a question from our brother just before we went to that very short break, and I will continue to address his query. So our brother asks us in relation to the 10-year immigrant policy. The brother mentions that he has already enrolled his biometrics 7 months ago, but he hasn't received any further information. Usually, if you're enrolling biometrics, brother, you will have made some form of an application. That there are two applications that come to mind, and these are immigration applications. The first one is the 10-year route to settlement. This is an application usually where an individual is in the United Kingdom and is a parent of a British citizen, a British citizen child, or has a child who has been present in the United Kingdom for a period of 7 years and it is deemed that it is unreasonable for that child to return to the parent's country. And so this route usually is granted for a period of 2.5 years, and at each 2.5 year interval, an application is made for an extension until a total of 10 years have been completed, and then you would apply for indefinite leave to remain. If that is the application that you've made, brother, and you are still waiting 7 months after enrolling your biometrics, then do not worry. It is a department that is experiencing, like many other departments within the Home Office, significant delays, and a 7-month delay, unfortunately, is not uncommon. In fact, we're seeing much lengthier delays in processing such applications. I don't know if you did the application yourself, or if you were represented. In either event, it might be worth writing to the department where you made the application. If you are legally represented, then your solicitor or your legal representative will have access to various email addresses for the relevant departments and should be able to follow that through. If you're not legally represented, you may seek advice from the Citizens Advice Bureau, or even go to one of your local solicitors and seek their assistance. Alternatively, you might want to ask for assistance from your local MP so that they can chase this with the Home Office and obtain an update. But as I say, it's not uncommon for these types of delays, so please don't panic or worry. At the moment, this seems to be the norm, and you probably will be waiting a number of months more before you hear back from the asylum teams. So if that's your query and that is the delay, then, as I say, please don't worry. The other alternative 10-year application that usually our clients make, again, an immigration application, is the 10-year lawful residence. This is where an individual has been in the United Kingdom with lawful residence, continuous lawful residence, so they haven't broken that, they've not overstayed or made an application late, for example. Then in those circumstances, upon reaching 10 years lawful residence with evidence of their residence in the United Kingdom, an individual can apply for indefinite leave to remain to the Home Office on that basis. Again, it's not uncommon for there to be delays. If you have made such an application and you've not heard back from the Home Office, then again, follow the advice that I gave in respect of the other application. Ask your legal representative to chase it up. It may be that if you are legally represented, that your solicitor is chasing it up. Unfortunately, at the moment, the Home Office is simply sending out template responses, just confirming simply that there are delays and that your application is under consideration. There isn't anything kind of more material that they are providing. Certainly the Home Office doesn't provide a time frame as to when decisions will be made, and there doesn't appear to be a method in which we can establish which applications will be determined and in what order. So it does put our clients in a very, very difficult position sometimes. But if it is the delay that's concerning you, then please be assured that that is common at the moment, and it's not just your application that is delayed. But you can follow that through in the manners that I have described. So thank you so much for sending your question through. I hope I've addressed your query, and I'm sorry that I didn't understand it fully. If I have missed anything and I haven't actually addressed your question, then please either call me in the studio and speak to me live, or send another question through on WhatsApp, and I will address that further for you. Moving on to the next question. We have a question here. I just need some advice regarding my son. I was in a live-in relationship with his father for 1 year, during which I conceived my baby. His father is from France. I'm not sure about his status there. I would like some guidance and advice on what my options are in terms of obtaining child support, and if there is any way I can add him on the birth certificate registration. he cannot travel here due to his status in France. Thank you for that question. Again, an immigration-related question, but also elements of child maintenance in there. If you had been watching at the start of the programme, I addressed a similar question, particularly around child maintenance and the other partner not being resident in the United Kingdom at the time you seek child maintenance. The Child Maintenance Service is quite clear in its guidance that an individual who is seeking child maintenance and is requiring their assistance would usually require both parents to be habitually resident in the United Kingdom alongside the children that they are claiming for. Your partner or former partner is not in the United Kingdom, and so it's unlikely, unless he enters an agreement with you and provides support, that the Child Maintenance Service will be able to assist you with that. But however, as I gave the advice earlier, your local Citizens Advice Bureau will be able to sit down with you and assess fully your circumstances and whether or not a claim for child maintenance can be pursued in your particular circumstances. You mentioned that the father of your child is in France, but you also say that he's unable to travel due to his status in France. I'm not sure whether that means that he has a lack of status in France, so he's living there unlawfully, or what it is that prevents him from entering the United Kingdom. My understanding with regards to father's details on a birth certificate is that the father will need to be present for that to happen. There may be other ways of the father consenting to him being registered as the father. That is something that you will need to explore further. Unfortunately, I'm not familiar with those details, but my understanding is that usually it is a requirement that the father is present when the name is registered. I hope that does answer your question. If it doesn't, if I've missed anything, then please feel free to ring me in the studio or to send a follow-up question on WhatsApp. Of course, if your baby's father is a French national, which it doesn't sound like from your question, but if he is, then there may be the option of your child actually applying for French citizenship as well. So another avenue for you to look at. But it's you will need to have that conversation with your child's father about his status in France, and you know how that will impact on your child and whether or not your child is entitled to anything by virtue of that. So thank you so much for sending that question through. Brothers and sisters, if you do have any questions, please feel free to contact me directly in the studio. The telephone number you see at the bottom of the screen, the landline number, will bring you straight through to speak to me live on air. If you wish to remain anonymous, that's absolutely fine. Please feel free to send your question through on WhatsApp, and I will go through that and provide you with any assistance that I'm able to do so, and to clarify any legal queries that you have. Your question does not have to be restricted to any immigration queries. We've had a broad range today of immigration and also some family law, maintenance type queries, but you may have a query in respect of employment law, criminal law, or any other law or field of law under English law. As long as it is within the jurisdiction of England, then it is a question that I should be able to address for you. I don't specialise or qualify in any other jurisdictions, and I'm not familiar with those to address any questions. But thank you so much for the questions that have been sent through so far. So we have a question in respect of biometric residence permits. Again, an immigration query. Biometric residence permits are issued currently by the Home Office and replaced many years ago the vignette that used to be placed within passports to confirm an individual's right to remain in the United Kingdom. It is a credit card size card that addresses that sets out, forgive me, the details of the bearer and also the start and expiry date. And a common question that we get and has been asked again today is the expiry date on those biometric residence permits. If your leave expires beyond the 31st of December 2024, then you will find that the expiry date on your biometric residence permit is the 31st of December 2024. That isn't because your status has expired. It just simply means that the Home Office currently, again due to European regulations that we were formally adhering to, is unable to issue these types of cards beyond that date, and is currently formulating some kind of policy as to what will replace those and what type of permit or identification system will replace the current biometric residence permits. But that policy has not yet been issued. So when it does, we will provide an update in relation to that, but stick to the letter that confirms the expiry date. That brings us to the end of today's show. Thank you so much for your questions and watching me today. I will be back next week. Thank you. Assalamu alaikum wa rahmatullahi wa barakatuh.